It's a medical malpractice trial. The judge has now sent the jury out to go reach a verdict. And now they're sitting there for hours and hours trying to come to a decision, and one of the jurors, one of them, can't reach a decision. She can't decide whether she should vote in favor of the patient, the injured patient, or in favor of the doctor. And now she doesn't know what to do. She wants to ask the judge a question about whether she can make a phone call to a trusted friend in order to help her make that decision about who she should vote for. Can she do that? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You know in the show Shark Tank, where now somebody's making a pitch to the sharks, and now they get a series of offers? Before they make an actual decision, they want help from their trusted advisor. Well, now many times they're told, go ahead, go make your call. And now they go out into the hallway, and a few minutes later they come back with an answer about whether or not they're going to accept one or more of the offers. Now, can they do the same thing? Can a juror do the same thing in a medical malpractice trial here in New York? The answer is no, they can't. And I'll tell you why. At the end of the trial, the judge will turn to the jury and say, ladies and gentlemen, the testimony has now finished. It is now your obligation, after I give you the instructions on the law, to go back and reach a verdict in this case. Now, you should know something very important. A verdict is not simply the jury answering one single question. Who is your verdict for, the patient or the doctor? That's not how it works. Instead, the jury is asked to answer a series of questions step by step in order to reach their decision, their verdict. And now, what are some of those questions? Was the doctor careless? The technical language is, was the defendant negligent? That's what the jury has to answer. If the answer is no, the case is over. It's finished. If the jury decides, yes, the doctor was careless and was negligent, now they have to answer the next question. Was that carelessness a cause of your injury? Yes or no? If the answer is no, your case is over. You get nothing. If the answer is yes, now the jury will then go on to evaluate the amount of money you are to receive as a form of compensation for all the harms and losses and damages that you incurred because of your doctor's carelessness. So now, let's go back to the original question I posed in this video. If one or more of the jurors cannot reach a decision because they are confused, because they need help, because they don't trust themselves, and now they want somebody's help, an outsider, to now give them advice about who they should vote for the patient or for the doctor. Now, do you think that's fair? The reality is, no, it's not fair, and let me tell you the basic reason why it's not. It's because whoever it is that they call was not present in the courtroom during the entire length of trial. That person did not hear the testimony. That person did not see the evidence. That person did not hear the legal rulings that the judge made on this case. That person did not have the benefit of listening to the other jurors deliberate and listening to their opinions. Because of that, this person now is at a significant disadvantage. And besides, the whole purpose of having a jury who's sitting and listening to testimony each and every day is so that now they can come to an educated decision amongst themselves and have a discussion amongst themselves to decide who is more likely right than wrong. Is the injured patient more likely right than wrong that what she is claiming is true? If so, then she deserves a verdict in her favor. If not, then she doesn't. And it's as simple as that. There are some jurors who, for whatever reason, are unable to reach a decision on their own. And now they feel they need help. Somebody, a trusted friend, a relative, a parent maybe, and now they want assistance, guidance. Well, here's something else that you should know that I think will be very eye-opening. In New York, in these civil lawsuits involving accidents and medical malpractice and even wrongful death, there are 6 jurors, 6 members of the community who sit in judgment on these types of cases. And now, not all 6 people need to be in agreement for each one of the questions that are answered. They don't. It does not have to be unanimous. Instead, there has to be at least 5 out of 6 jurors to answer a question one way or the other in order to reach a decision on that question. So that's all that's needed. We only need 5 out of 6 jurors to answer a question about whether or not the doctor was careless. So if this one juror can't make a decision and ultimately says, you know what, I'm going to decide the doctor was not careless. If the other 5 members of the jury said, you know what, he was careless, then guess what? Now they all go on to question number 2. And the question number 2 is what we call causation. Is there a link? Is there a bridge, a connection between the wrongdoing and the carelessness and your injuries? So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these civil lawsuits here in New York. You know, I recognize and I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.